But welcome everybody once again.
Thank you,
We're just going
everyone.
to wait until 12:05 before we start the official panel. So thank you for waiting and thank you for signing in. I'll just give some free remarks before I start the formal introductions, but this is for the Task Force on Linguistic Polity, le Comité Spécial sur la politique linguistique. We're here to present our legislative brief on Bill 96. So we prepared a very fulsome brief on particularly the constitutional aspects, but on the aspects that touch upon all aspects of civil society. That Bill 96 really isn't a language law, as you'll learn. It really is a reconstructing of our society and basic fundamental freedoms in the province of Quebec, and touches upon other provincial and federal aspects as well. So we're just going to wait for the attendees to sign up a bit more and give it another 2 minutes. But really do appreciate everyone being here today. And as well, some other remarks is that we decided to have these sort of our press conference to dévoile our legislative brief, because we were not invited to the National Assembly's hearings. They are ongoing this week. I encourage everyone to tune into them. I know that Townshippers Association has a very holistic brief prepared for, I believe, this Thursday. I encourage people to look at their presentation and also other presentations. Everyone is quite worthy. Once again, we're quite dismayed that we were not invited, and as well other Quebecers were not invited to the National Assembly. So that was part of the reasoning that we wanted to be here today and to have our own panel discussion, so our own mini hearings with Jerry Cutting, who's president of Townshippers, with Brent Tyler, very well-known constitutional lawyer, and then Keith Henderson, very well-known activist and former leader of the Equality Party, a Quebec provincial party. So once again, it will start in another minute or two. I'm just giving some free remarks as introductory sort of background on everything. So my apologies, but we'll wait until at least 12:05, and I'll wait for Mark Perez to begin the meeting. And just some other introductory remarks that I really want to thank everybody for, the work on the brief. I'll go over this a little bit. There's so many thanks to go around, but as well, the communications team here. We have a really exceptional group, Mark Perez, Craig Steinberg, and as well, Tom Merson. So we really have some exceptional people. Tom is a professional consultant in social media strategy and communications. Mark Perez is a jack of all trades and master of all as well, I would say, in regards to digital communication. Craig Steinberg is a web designer, and he works on the front lines during the pandemic at as a first responder and in ER rooms. So we have a really exceptional group, and I feel very privileged to have them on the group, on the task force. So I think we're almost up to 50 or so new people. So yeah, attendees keep on rising. So I'll wait for Mark Perez to let me know when to go ahead.
Thank you, Colin. I just wanted to mention that if anybody has any questions during the presentation, that they should use the Q&A button that is always found on the bottom of their Zoom window. They could raise their hand or ask a question directly in the Q&A. If we have any news reporters that wish to verbally ask the question, they could ask the question and identify themselves in the Q&A, and we will give them the right to ask a question. Okay, and I think we are good to go. Colin, the floor is yours.
Yeah, thank you so much, Mark. I really appreciate it. And thanks so much for coming here today. And I just wanted to address some of the structure today. So I'm going to give a brief introduction about the task force, what our brief is about, and then go into the brass tacks, a lot of the constitutional law, legislative amendments. We're going to have Andrew Cadell, another member of our steering committee and executive team. He's going to take the sort of second part of the brief presentation. Andrew Cadell, very articulate for columnist at the Hill Times, former diplomat and journalist. And then we're going to go to a roundtable discussion with our panelists for a sort of mini hearings to present our brief, and as well talk about Bill 96. So Jerry Cutting, president of Townshippers, Keith Henderson, former party leader of Equality Party of Quebec, Brent Tyler, very well-known constitutional lawyer. So we're all very thankful to have him here today for an enlightened discussion. And then we will proceed. There is a message in the chat at this time, but we will proceed with questions from media after the presentation, and then questions from other members, time permitting. So thank you. That's the structure for today. But on that note, I want to thank everyone for being here. It really means a lot to me and everyone in the task force for you to be here today at our hearings. That we decided to have these hearings because we were not invited, unfortunately, to the National Assembly, that we were locked out of the halls of power, unfortunately, and not able to speak truth to power in regards to Bill 96. So we wanted to make sure that our voices are heard, and we want to make sure all Quebecers' voices are heard. So that's the reason we wanted to do this press conference and panel today. We have prepared a very fulsome legislative brief. It's about 43 single-spaced pages that you can find it. You can find it in email sent around today and on our website. It is about 1,700 words, but I highly recommend if you wanted to download it, take a look at it during our presentation. It'll help frame a lot of what we're saying and what I'm saying. So I'll try not to go too much into the brass tacks, but please take a look at our brief. It is very fulsome, and I encourage you to read it to really understand what's going on with Bill 96. So I wanted to introduce a little bit about our organization, just very briefly, that I myself am Colin Standish. I'm chair of the Task Force on Linguistic Policy. We were formed by concerned citizens in late May and launched in June 2020 and June 21st, 2021. And we're a group of concerned citizens that really wanted to stand up for very fundamental freedoms in the restructuring of our society in regards to language rights and other fundamental rights and freedoms. And so we're a variety of concerned citizens, in fact, all over the world, but largely English-speaking Quebecers and other interested Quebecers. We do have Francophone members, we do have Indigenous members, we do have visible minorities, we do have female members. And so we do pride ourselves on being diverse. We need to include that and keep on expanding the circle. And I encourage everyone watching here today and others who might watch this in the future, please take a look at our website, protéger mes droits, or protectourrights.ca, to join up as a member of the task force. This is to volunteer. We always want to expand the circle. And as right now, we do have about 1,000 formal members. We've raised about $15,000, and we do have an executive committee, and we do have a steering committee to provide oversight. We do have regional chapters being formed throughout Quebec, so actually to give a regional basis to it. We have very active chapters in the Eastern Townships, Western Quebec, Central Montreal, and are in the process of establishing other ones throughout the province of Quebec. And so, once again, I wanted to as well take some time to thank people who have made this brief possible. Ben Huat, who cannot be here today, unfortunately, he's closing a house that he owns in Arizona, so he had to be away, unfortunately. He was integral to this brief. Ben Huat and myself, I helped out with the brief, obviously. Derek Hetherington, Rahul Majumdar, Patrick Quinn, Brent Tyler, Keith Henderson, Moira Regan-Bell, and David Christiani for all their contributions. I need to recognize how much their hard work was integral to this brief. So on that note, I'll get into the introductions. That the primary thing I wanted people to understand here today is that Bill 96 is not even just a language law. It redefines and restructures language in Quebec and Canada in fundamental and illegitimate ways. This is the re-engineering, this is re-engineering, and it's incompatible with individual rights, natural justice, human and civil rights, national unity, and a bilingual country. The task force has and will be fervently opposing Bill 96's excesses. The bill contains over 200 amendments, including vast search and seizure measures, restrictions on who is entitled to receive government services in language of their choice, a cap on English CEGEP enrollment, and a false definition of who qualifies as a member of the English-speaking community of Quebec. It also seeks to eliminate bilingualism in more than 50 of 89 bilingual municipalities. In effect, Bill 96 deinstitutionalizes, delegitimizes, and disestablishes the English language and its speakers in the province of Quebec. The task force's primary reservations in a global sense are sixfold. The Bill 96 does not promote, protect, or increase the French language in usage, home language, mother tongue, or first official language spoken. This bill does not protect French. Secondly, Bill 96 effectively erases the English language's institutions and individual speakers from civil society and public administration in Quebec. Thirdly, the proposed unilateral constitutional amendment is in itself unconstitutional and ill-advised public policy that will affect other parts of the Canadian Constitution. Fourthly, changes in the interpretive framework for Bill 101, the Quebec Charter, and other laws like the Civil Code and the Interpretive Act and the Code of Civil Procedure will distort fundamental freedoms and human rights in the province of Quebec. Freedom of expression, fifthly, freedom of expression, commercial expression and practice, work and employment, contractual liberty, freedom of education are constrained for all Quebecers, regardless of your linguistic background. And sixthly, the use of provincial and national notwithstanding clauses will suppress basic human rights for all Quebecers in extreme and illegitimate ways, at home, at school, the workplace, and their commercial transactions. The task force will discuss this in a holistic way, in the way that this bill is detrimental to the rights of all Quebecers. And that's one of the primary things before I get into the brass tacks of it in regards to what I think people should take away, or I'd like people to take away from this presentation, is Bill 96, taken as a whole, is a fundamental and illegitimate restructuring of our country, our province, our constitution, the relationship between citizens and the state, and our relationship between each other. The bill serves to erode, erase, and extinguish the fundamental freedoms of all Quebecers, be they French speakers, English speakers, Indigenous, or newcomer. All Quebecers are intimately affected by Bill 96. The bill as well surgically excises the English language, literally line by line by line, and its speakers and institutions from Quebec. The task force is calling very precisely on the governments of Canada and Quebec to do several things. So this is to take note. We have not made exactly what we feel in this regard public until now, but the task force is calling on the government of Quebec to do 4 specific things. One is open up the hearings and consultations to all Quebecers. Secondly, produce an independent legal analysis of the bill, line by line, of each article. 3, refer Bill 96 to the Quebec's Court of Appeal regarding its constitutionality. 4, we also call on the government of Quebec to withdraw Bill 96 in its entirety for the reasons that we will discuss in a brief. Secondly, the task force is calling on the government of Canada, which does have a responsibility in regards to this law as well, in 5 separate areas. 1, we would like them to produce their analysis of Bill 96 that inform their views on Bill 96. And we have lodged an access to information request in early June, which we still have not had an answer for over 100 days after filing. Secondly, we call on the federal government to speak out against the flagrant unconstitutional aspects of the bill. Thirdly, refer key aspects of the bill as a reference question to the Supreme Court of Canada. Fourthly, instruct the Lieutenant Governor of Quebec to reserve the bill. Fifthly, to disallow Bill 96 should it pass. That the federal government does not only have a moral responsibility to protect basic rights and freedoms and language rights in Quebec, they actually have the constitutional power to stop Bill 96, and we need to remind them of that. So I'm going to go into, I don't want to say line by line analysis, but if you are following along at home, I think page 6 of the brief would be a good place to start. But I'm going to go over things grosso modo, so get the large picture of the different aspects in Bill 96. But I'll leave a lot of the very, the more sophisticated analysis, quoting case law. I'm not going to speak about that as much as I have in the past, so I'll try to cover it in a very broad strokes manner. So just if you want to follow along, highly recommended, and as well, very much open to questions. And my apologies as well, I am speaking mostly in English today, mais je peux parler français aussi, et je veux des questions en les 2 langues officielles. Ça va être un plaisir la fin de notre présentation. So the first thing I'm going to speak about is the proposed constitutional amendment. That's section 159 of Bill 96 that says that it's going to add to the Constitution section 90 Q1 and Q2 that say Quebecers form a nation and French shall be the only official language of Quebec and is also the common language of the Quebec nation. There's a lot in there that I think even people haven't really noticed. And once again, this amendment is unconstitutional in and of itself. The substance of it actually proclaims a nation. Not many people notice nationhood in 2 ways. It says Quebecers form a nation, and then it says Quebec nation. And nation is inserted into the Constitution in a way, into our Constitution, particularly the 1867 Constitution, that is binary. You have provinces, you have the federal government. Nothing else really matters. Territories, municipalities, Aboriginal rights, more or less came much later, but you really have a very binary structure in regards to jurisdictions in our country, provinces and the federal government. A nation is not contemplated in our Constitution. The nation of Quebec is proclaimed in 2 ways: to a distinct Quebec-associated people, might this include expatriate Quebecers, it's not well defined, and to the territory and jurisdictions of the province of Quebec. Quebec, when referenced as just Quebec, refers solely to the province of Quebec and limited by its constitutional jurisdiction. And these 2 proclamations of nationhood are seemingly defined solely by the French language, and I'll discuss that a bit below. But the proposed constitutional amendment is supposedly legitimized by the government of Quebec under Section 45 of the Constitution itself, that the process that they are saying that Quebec can modify unilaterally the 1867 Constitution is unconstitutional. And so I'm going to talk a little bit about it. I would ask people to look at my brief for a more in-depth analysis, but I'll try to talk about it as much as possible. So once again, the Section 45 route to a constitutional amendment is not actually explicitly in the bill. It's been stated verbally, but once again, it's not actually in the bill, just like some other aspects of it. And I would refer people to it that Section 45 really, the Constitution of Canada cannot be modified in that way. That the provincial, Section 45 is applying to an amendment in the constitutional, if the Constitution of the province only when the provision can be amended is not found in any instruments comprising the Constitution of Canada. So once again, the written Constitution of Canada, 1867, 1982, and the 30 other acts explicitly mentioned in the annexes of the Constitution, they cannot be touched by a method of the Constitution. So Oh, we're going to the actual analysis. So, and as well, just wanted to go over section that once again that the constitutional amendment cannot be done in that format. And going a little bit lower on the page, it's great that Mark's called it up, but section 43 might apply to part of the amendment that French is also the common language of the Quebec nation, meaning that there's a modification to the Canadian Constitution in regards to the use of English and French that falls outside section 45 and as well 43. Section 43 is when the province and the federal government can modify it in a bilateral way. But however, I would believe, and the task force believes, that unanimity, so that means all provinces and the federal government would be the way to do this amendment. So the dual nation proclamation would not fall under any established amending formula, thus requiring either the unanimity or the general amending formula for section 38. So it is a very complex analysis. I would once again to refer to the actual brief itself would perhaps assist going forward. I do want to touch as well, and the second topic I'm going to talk about today is Quebec's official languages. There is the implied restructuring of our Constitution and Quebec's legal status. This is found in the preamble of Bill 96, Section 1, and as well Section 2, and it is throughout the bill itself in Section 62. My analysis is they seem to add throughout the bill is Quebec Nation. So Quebec Nation incorporated into the preamble twice. As well, only French-speaking state in North America is proclaimed. As well, state is used, capitalized state, parliamentary sovereignty, Parliament of Quebec. These are a variety of very loaded terms. They do have certain legal, they do have sentimental meaning, but they do have legal meaning as well. I'll take each one of them down. I did talk a bit about nationhood, that once again, nation is not contemplated by our Constitution. But the term only French-speaking state I find quite offensive, is that it's factually incorrect. Manitoba, New Brunswick, and Canada all have to pass legislation in French. Haiti is a French-speaking state in North America, even though it is in the Caribbean. Quebec itself has 20% of its population that is non-francophone. State is used as a statehood. Here, it seems they want to confer some sort of statehood, meaning status of an independent state on the international stage in law and international relations. Parliamentary sovereignty, Parliament of Quebec. These are very new terms that are not generally used. This seems to imply a sovereign legislature, presumably after some sort of independent or sovereign Quebec. Parliament of Quebec is usually just used for the Hotel de Parlement. It's quite common in French to refer to the Parliament of Quebec as just the building itself, but never as the institution. The Assemblée nationale is simply a body housed within the Parliament of Quebec. It has not been used in this way before. Taken as a whole, the terms Quebec Nation, only French-speaking state, state, parliamentary sovereignty, Parliament of Quebec, and Quebec spelled erroneously without an accent all seem to factually, legally, constitutionally, politically, and morally confer and imply an illegitimate legal status. That Quebec, a province defined by the Constitution Act of 1867 and created in the United Kingdom's Royal Proclamation of 1763, that is ultra vires, meaning unconstitutional of the legislature and current legal status of an unaccented Quebec, which is an entity of law bounded by the Constitution of Canada. As well, I want to talk a little bit about the terms in the Section 2 and Section 62. They refer to common language, and as well that the only official language of Quebec is French. Common language, this term that's used throughout the bill, it seems to perpetuate the legally and politically unfounded idea that Quebec is solely or the most critically defining characteristic of being a Quebecer. Secondly, the only official language of Quebec is French. I want to be clear about this. French is not the only official language of Quebec at the provincial level. Is that once again, Quebec is defined by the territory comprising provincial and federal jurisdictions that is constitutionally defined, has English as the official language. This is in Section 133 of the Constitution, that English and French have equality of status in our courts, our legislature, laws, regulations, and in the National Assembly itself. English and French are inseparable from the ability to pass laws or to regulate the state of Quebec. That aspects of Bill 96 which purport to confer some unique and singular officialdom on French are either declaratory or symbolic, of no legal force and effect as they relate to delegitimization, deinstitutionalization, and disestablishment of the English language in Quebec, and are ultra vires, once again, of the Canadian Constitution. I'm going to talk a little bit, there's a lot of other things, even though these have sort of been noticed. There's changes in the interpretive framework for Bill 101, the Quebec Charter, the Civil Code, the Civil Procedure Act, and the Interpretive Act that people haven't talked about that much. This is on page 13 of the that every act must be interpreted in a manner respectful of the rights intended to protect the French language and conferred in the Act. Section 63 The significant revision to bilingualistic statutory interpretation, that once again, section 133, that has equality of status for English in the courts, laws, regulation, and legislature is perverted and distorted by this. The predominant interpretation of French in the interpretation of the statute is illegitimate and unconstitutional under the Constitution. The equality of English and French has been upheld, notably in the Supreme Court cases, Blakey 1, Blakey 2 in the early 80s, and they overturned the predominant French aspects of the original charter of the French language. There are a variety of other ones. I'm just going to talk about these interpretive changes are really, really important. However, I just wanted to point them out, and I'll try to go over them as briefly as I can. In the Civil Code Civil Code of Quebec, that the Charter of the French language is written into the interpretive framework for the Civil Code of Quebec, and seems to imply that the Charter of the French language has a predominant interpretive status to the Civil Code in the Charter of Rights and Freedoms of Quebec. This signals a fundamental revision in the interpretive framework for the Civil Code, which regulates nearly the entirety of private and public and civil rights in Quebec. Article 122 is changed as well, that official acts of civil status must be drawn up in French and only declarations in English. Once again, this is a very fundamental revision. Section 123, this is an unconstitutional section that it says that it strikes out English in regards to the official status of civil status or juridical acts in Quebec. Section 124 is much the same. If you go line by line, they literally excise the English language from the Civil Code. So really that regulates, once again, the baseline of all our private and public rights in the province of Quebec. Some other aspects here is that the preamble of the Charter of Human Rights and Freedoms, that's a quasi-constitutional law, so above every other right, every other law in the province of Quebec. They've been tinkering with this, so they are tinkering with the interpretive framework as they did before with the Laïcité Act, but they're adding Quebec Nation and a variety of other things into the preamble of the Charter, and this over time would pervert and distort the entirety of our laws and court judgments in Quebec to make the predominance of French above every other basic right and freedom. Section 134, 135 of Bill 96 as well, in regards to limitation clauses, and it's very important because the importance and protection of French is now incorporated into such a critical legislative article of law, that being the Civil Code and the Charter of Human Rights and Freedoms, that not only frame the rights under the Charter or the Civil Code, but they have a quasi-constitutional status that places it above all other Quebec legislation. Though, if Bill 96 is adopted, the Charter of Human Rights and Freedoms itself will conform to the Charter of French language. It's a very structural revision to our constitution, or sorry, more accurately, our provincial constitution in an accurate way. As well, this Code of Civil Procedure, that there's a new predominant framework for the Charter of the French language. There's now a reference, section 146, to the Interpretive Act. So there's a very bizarre statutory interpretive framework for all statutes which place the predominant French above every other human right and freedom. That you must use French only in the performance of your obligations. So once again, this is very brass tacks legal analysis, but we haven't heard much about this in the public sector, in the public discourse in regards to the things that aren't the constitutional amendment. But they really have, I would say, almost, well, in different ways, but really in a very brass tacks way that will start almost day one if Bill 96, what happened to pass, would affect all our basic human rights and freedoms and our ability to contract in our civil relations amongst each other. I'm going to talk a little bit about CEGEP admission. So it's been talked about, thankfully, in the public discourse. But once again, it upends meritocracy. That your admission to post-secondary education is based on an inherited ethno-linguistic background designated by the state is abhorrent to myself and the task force. That now that people have talked a lot about historic or heritage Anglophones, that's not actually in Bill 96. For as much as everyone's spoken about it, that it's all based on the eligible to receive instruction in English status, which is defined by Division 1, and as well I'm going to talk a little bit about it a bit later. But once again, it's a very convoluted backdoor way to limit our basic rights and freedoms and access to public services in CEGEP, and we're going to talk about healthcare and social services a little bit later. But once again, this backdoor way to constrain the ability of the English-speaking population to define itself. That 1.2 million English speakers is usually the relevant anchor. If you looked at first official language spoken and home language, if you just look at mother tongue, it's about 600,000 people. So once again, you can deflate it by half or double it depending on how you choose to count it. I'm skipping ahead now to a little bit later in the brief if you are following along. And I'm going to talk about bilingual status at page 23. So this is one thing that is very critical to is very critical in Bill 96, and as well, I don't think it's been adequately discussed, even though it has been part of public discourse, is that there's other aspects of changes in municipal status. So Section 5, and then as well Section 137, that they're actually taking away the rights to adopt bylaws in English. So that's no longer going to be a right even for bilingual municipalities, and some other municipalities pass them bilingually as well. I find one aspect of it that is particularly abhorrent is in Section 137 is that the Cities and Town Act that you can actually publish notices in English and in French, or they have to be in both. So those are usually emergencies. If your water main exploded, there's too much snow on the ground, something like that. But French is going to trump public safety now for public notices at the municipal level. Those are one thing that not many people have spoken about. In regards to the constraining of bilingual status, that that once again a majority must be mother tongue English speaking to have bilingual status, I think is already an onerous burden. That it used to be that it was a majority didn't speak French could have bilingual status. Instead, it was changed to a very convoluted formula. But the census data will lead to 50 of 89. So an actual majority of municipalities, 50 of 89, will lose their status unless within 120 days they choose not to revoke it. But the problem is if you forget, something's lost in the mail, literally, if you have a council or mayor who are intransigent, who don't want to pass it, there are certain communities where there are vestigial populations of only single digits of mother tongue or Anglophones remaining, that they might lose their status very quickly. That I think every census you're going to see, I'd say 3 to 5 minimum, maybe up to 10. It'll be the slow accretion over time. Once again, the extinguishment of the English language in the province of Quebec. And as well, one thing that always bothers me when we talk about bilingual municipal status is that no French speaking Quebecer, no French speaker from anywhere in the world has less rights to any service or signage, has less rights to it in French in a bilingual municipality than they do in a unilingual French municipality elsewhere in Quebec. No Francophone has less rights in a bilingual municipality. So why are we taking it away? How does that promote or protect French? I think that part of Bill 96's intent is fairly obvious in this section. I'm going to move on now to page 26. The notwithstanding clause in the charter. This is one thing, hopefully, thankfully, it has made a lot of public discourse, but it is something to mention. Is that one thing I wanted to mention is not, it is detrimental, it is horrific, it is not something we should allow to become commonplace, and unfortunately it has been in the last several years, is that once again, that the charter is only partly insulated by Section 2033. I think people think that notwithstanding clause invoked, you have no more rights and freedoms, etc. That's sort of true for the provincial one. It is, and they've done a derogation of 1 to 38, so the entirety basically of the act. But the federal charter is only very limited. Sections 2, 7 through 15 can be opted out of for only 5 years. So once again, I don't want to delegitimize how important it is, but once again, 5 years, only part of the charter. That actually 2/3 of the charter still stands. It doesn't touch Section 33, so the notwithstanding clause federally, doesn't touch democratic rights, doesn't touch mobility rights, doesn't touch language rights in certain aspects, or the enforcement of the gender equality clause. So I just wanted to let people know that even though the notwithstanding clause is invoked, it doesn't mean all hope is lost. It's a bad thing, but it's not necessarily the can't go to court is what people often frame it as. That's not accurate. And as well, there are ways in which it is more theory, and hopefully it is tested for Bill 96 if it would to be passed, is that Section 1, so the limitation clause of the charter, can be applied to Section 33. This has not been tested yet in the courts, but once again, you could neuter part of the notwithstanding clause with another part of the Constitution, Section 1. This is one thing that I think we need to try if indeed Bill 96 does pass, which I do not want to see. As well, in the next page, 27, there are some very bizarre parts of Bill 96. So the naming of a child is actually changing. Section 121, it's sort of outlandish where acts of civil status we now use French names. That people that are from around the world or Indigenous Canadians, if they have anything that's sort of not an Anglo-Celtic name, it would be forced to be solely in French going forward. It's a very bizarre little change. I don't know why we can't let people name themselves for themselves or what their parents decide. As well, we're going to go down to civil sanctions. Section 20 is on page 27 as well. These are very onerous penal sanctions, $700 to $7,000 for an individual, $3,000 to $30,000 in fines for a corporation or other entity. And then there was doubled or tripled for recurrences of the same infraction. So once again, up to $90,000 for a small business who doesn't abide by Bill 96. $90,000. What kind of small business after a year and a half of the pandemic can afford a $90,000 fine? And we would presume maybe these things are for egregious, onerous, things that are done by individuals to delegitimize the French language or Quebec. But let's take a look at what they apply to. I was really surprised when I took a look at it. So the $90,000 fine or $21,000 for an individual, that applies to no person may permit or tolerate a child's receiving instruction in English if he is ineligible therefore. What does this mean? Is that an example of this is that if you let your child in your home read a storybook in English to a neighbor's child who lacks Section 23 right, let's say they're a new Canadian or a French speaker without the right to English education, you can have a $21,000 fine. If you had a home business, this could be increased to $90,000. This is actually in Bill 96. This is not a ridiculous example where I'm trying to distort and pervert what's actually in the law. You could have a $21,000 to $90,000 fine for merely tolerating a child's receiving instruction in English if they don't have the Section 23 right. That's how far this law goes in perverting and distorting our rights and freedoms. I'll try to wrap it up pretty soon. Andrew Kiddell has a lot to say, and I'm sorry I'm always very long-winded, but I do have a few more things, is that there are division of powers on constitutionality. So that means the provinces have certain jurisdictions, the federal government. So once again, even though the charter's opted out of in part, there is still divisional aspects of the unconstitutionality, particularly Section 65 and 47. Those regards to they want to apply to every single enterprise and jurisdiction and business in Quebec. Once again, the Quebec government does not have rights for federally regulated businesses, which is what they want to do. And as well, federal labor jurisdictions are not an anglicizing force in Quebec. Please take a look at my brief for an analysis of this, that it really is something that is not an issue. But once again, the Quebec government does not have jurisdiction here, and this will be struck down by the courts very quickly. As well, in regards to trademarks or a federal jurisdiction in Canada at Section 47, this will be struck down by the courts. As well, government services and restrictions. This is a very big one. It's page 29. Please take a look at Section 15 of Bill 96, and it's quoted there. And so this is once again similar to the SAGEP thing, and almost similar to the SAGEP thing, is that you need to be declared eligible to receive instruction in English to receive government services in Quebec. So how do you do that? How do you be declared eligible to receive instruction in English? So you need that Section 23 right, an eligibility certificate. So one parent must receive an eligibility certificate. And what happens though when many English speakers do not have a certificate, if they attended school before 1977 or attended French school or a private unsubsidized school, therefore most English speakers above the age of 60 will not have the certificate. If you are once again grandfathered in, you attended English school before the year 1980 or so, and if your parents have passed away, unfortunately, common occurrence, you get to a certain age, you cannot request a certificate of eligibility. So once again, this constrains services to a fraction of Section 23 rights holders for English services, for government services in English language. That most people require healthcare, government services, and are born unilingual when they're at a certain age, baby boomers, age 60 and above. They will have no route to actually receive an eligibility certificate, and there's no alternate route contemplated in Section 96. Very bizarre, but also, once again, it limits rights and freedoms to not even mother tongue Anglophones. It's a fraction of mother tongue Anglophones who have Section 23 rights. This not only takes it down to, once again, a couple, maybe 300,000 to 400,000 English speakers in Quebec have the right to government service. There's some other bizarre little point I wanted to show you guys, is that musical choice is that the implementation of French language environment, in particular with regards to vocal music and the priority given to Quebec cultural works. This is Section 18. So what this means is that Quebec French language music will be coerced in all government offices. This bill really goes that far. There's another part, this is page 30, and this is one of the things that I think we need to take forward to make sure everyone in Quebec realizes that search and surveillance and seizure, Section 107, 111, 113, these these upend centuries, almost a millennia of basic rights and freedoms in the Western world. Is that hypothetical complaints by anonymous complainants could lead to a warrantless, nearly charter-free search of your premises by inspectors. Any electronic device or of a client, employer, owner could be examined and searched. They want to take our phones, and this is how far it goes. That you, as a client, as an employee or an owner could have your electronic devices searched and seized, you would have no warrants, you would have no charter rights, you would have no even rights to civil recourse should they rough you up or break your stuff. There's a variety of other aspects in it that if you want to take a look at the brief, we do have some really great parts on the professional code and other aspects to deal with professional regulation. Those were drafted by, in large part, by Rahul Majumdar, one of the individuals on the executive of the task force. I know Andrew's going to speak to those a little bit, so I'm not going to speak to them so much, but I highly recommend you take a look at them. They are very much an upending of, once again, our right to work in the language of our choice, and as well the freedom of professionals, that there are about 411,000 professionals in Quebec, defined by the professional code, who would have their rights and freedoms taken away by Bill 96. And yeah, just skipping ahead, and as well wanted to take a look at the last few sections of it were an economic analysis done of Bill 96 and page 41 and 42 and 43. And this was done by Derek Hetherington, very intelligent former professor at Champlain and Bishop's Universities, and I know him well personally. And so I recommend taking a look at this, at really the impact that our language laws have on the economy. And these are very brass tacks. I recommend you take a look, but I'm going to flip back to one section, much to the chagrin of Mark, who's laying out the slides. But I'm going to talk about the socioeconomic of English speakers just briefly before I end the formal part of this of my analysis here. Just one second, I got to flip back to it myself. But this is one thing that I wanted to just speak about, that it's very close to my heart, is that English-speaking Quebecers are actually poorer than French speakers. We are a socioeconomically disprivileged population, despite the myth of wealth and power. The Quiet Revolution sought to overturn the perceived and real socioeconomic difference between English and French speakers in Quebec. Two key terms are useful for understanding the English-speaking population now: the missing middle and missing out middle. The English-speaking community is defined by a declining population and an aging population, and what is described as the missing middle, with a low proportion of people aged 15 to 44, and a missing out middle having on average lower levels of income employment than their French-speaking counterparts. English-speaking Montrealers, this is at page 22 of the brief. English-speaking Montrealers earn $5,000 less a year than a Francophone. English-speaking Quebec, English-speaking youth in the townships, I'm in the eastern townships right now, earn $4,000 less a year than a Francophone with their same age and education. 51% of English speakers in the eastern townships, women, are out of the workforce. There's a feminization of poverty. English speakers are substantially poorer than Francophones. Fewer higher income Anglophones exist than Francophones, and the proportions of Anglophones falling below the LICO, the lower income cutoff, is significantly higher for Anglos than Francophones. English speakers are as well once highly well educated, and also a higher rate of low education. Those are two paradoxical things, but they do exist in the English-speaking population. And English speakers are likely to have 30% of us having a university degree versus about 20% of Francophones. However, this does not translate into higher income. In regards to Anglophones, are actually more in their labor force by about 65% to 64%. And unemployment is actually greater for Anglophones by a significant percentage, about 2%. And we actually earn less than Francophones when we're in the workforce. So once again, I just wanted to give a significant revision to what people think of as English speakers, that instead of having new onerous obligations that coerce Anglophones and will lead to worse socioeconomic status, we should actually look at the English-speaking population of Quebec with assistance and understanding, and recognize that they are a disprivileged population, one that needs help, not new restrictions and onerous burdens. We would all be better off. About 50% of mother tongue English speakers have left Quebec, compared to only 4% of Francophones. The exodus of Quebec Anglophones during the best working years of their life constitutes a real loss of human capital for the English-speaking community and for Quebec as a whole. So I just wanted people to reflect on that. English speakers are poorer than Francophones, definitively. And I take a look at the analysis there. It is all cited with academic and statistical briefs, so I would love to discuss it with anyone who would like to learn more. But I wanted to, so that brings me to the end of the formal aspects of the brief. I'll just say a few words that I hope, once again, even the discussion today about what's in Bill 96, this literally, even though I've talked for maybe half an hour now, it really scratches the surface of what's there. I think the QCGN, that's the Macro English Rights Group, has said it's sort of like an iceberg, right? That you sort of see the tip and everything's below the surface. I think is a very accurate analogy to Bill 96, but I would define it as a black hole that it sort of sucks in everything everything around it and distorts and perverts it in a way that that many people have a hard time understanding. So I think that it's sort of a black hole, that our human rights and freedoms, our basic civil rights, are being abrogated in ways and distorted in ways we don't even quite understand at this point in time. And that once again, all our basic rights and freedoms in the province of Quebec, whether we're French or English, however we should define ourselves, Indigenous or newcomer, whether you've been here 3,000 years or 3 years or 30 days, your rights and freedoms will be changed by this. And I wanted people to reflect on that very fundamentally. And as well, this really, I think we should stop talking about Bill 96 as a language law. That's ostensibly, it's a big part of it. I don't want to denigrate the language rights aspects of it. But however, this is a fundamental restructuring of our country. It is in many ways similar to the Meech Lake Accord, to the Charlottetown Accord, to even the 1995 referendum question. There are many differences. I don't want to be pigeonholed into saying that they are the same thing. But once again, it's very similar in the fundamental restructuring of our society, of our constitution, and our country. So I wanted to impress that upon you. Open to very much to Andrew Cadell's and the other columnists, as the other panelists speaking today. Thank you.